Hi, my name is Matt Eichelberger, and I am the founding partner of Eichelberger Law Firm here in Jackson, Mississippi. Now, we represent people all across the state of Mississippi in criminal defense matters and in workers' compensation matters. I want to talk with you today about the post-indictment phase of a felony criminal proceeding in Mississippi. Now, not all criminal proceedings in Mississippi are felonies. There are misdemeanors as well. We handle both types, and today I'm talking about the latter half of a felony proceeding. Okay, so as we talked about in the first video in this series, that'll be linked here below, the felony proceedings are usually divided into two separate phases. First, you have the pre-indictment phase, which is usually right after the arrest, through the preliminary hearing, all the way up to the grand jury. That's the other video. This video is about the post-indictment phase. What that means is an indictment has been issued by the grand jury, and the matter is now moving on to circuit court, where a circuit judge will preside over the matter. In circuit court, the first thing that's going to happen is the arraignment. Now, this is something that can be waived. You don't have to necessarily be there, but that's up to the individual judge. And listen, we have 82 counties. We currently have 22 circuit court districts. Each one of those districts have different procedures, and each judge might have a different procedure. It all is very courtroom dependent. So you need to speak with somebody who practices felony criminal defense in Mississippi to make sure that these things apply to your particular case. Even here in Hinds County, for example, we have judges who will allow you to waive your arraignment, and we have judges that won't. So again, it's very courtroom dependent. Now, at your arraignment, there's something special that happens. Your lawyer will stand up there in front of the judge and say, "Judge, this is my client," and state your name. And then they'll say, he or she has been served with a copy of their indictment. They've read it. They understand it. They wish to waive a formal reading of the indictment, enter a plea of not guilty, and ask for a trial date. Now, the next part depends on whether or not you are out on bond. If you're out on bond, the lawyer will ask that you be allowed to remain free on that same bond. If you are not out on bond, then your lawyer may ask for a bond to be set or that your bond be reduced. That's, again, up to each particular circumstance. Now, at the arraignment, the judge will set a trial date. Some judges will also set other dates, like a status conference date or an omnibus hearing or motions deadline. Again, this goes to the particular practice of each individual judge. And you need to talk with your lawyer about what all these things might mean and which ones will be appropriate or which ones will exist in your case. Now, since we are in circuit court, there are special rules that apply with regards to discovery. This is where you can file motions for discovery. You can compel the state of Mississippi to give you evidence that your lawyer can use to help put together your defense. Also, there are other types of motions that are available now too. Motions for what we call subpoenas duces tecum are real and something you can do in circuit court. That means you can compel other third parties to give you evidence. So phone records are a great example of this and something that we oftentimes see in felony cases after an indictment. That subpoena duces tecum is a command from the court to that third party that they give you a thing. And it can be something physical or it can be something digital like phone records. So once you're in this stage, again, you can issue subpoenas duces tecum. You can ask the judge issue subpoenas, regular subpoenas that we call subpoenas ad testificandum, meaning show up and testify. So those subpoenas will be available to you. Also, motions to suppress or motions to quash certain parts of the indictment or dismiss the indictment. Those things are also available after an indictment. Now, let's talk about the proceedings up until trial. Usually there are some negotiations back and forth during this phase about plea agreement. Most cases that reach this stage do, in fact, result in a plea. At this stage, there's only three ways for a case to be disposed of once we reach this post-indictment phase. either a dismissal by the state, an agreement between the state and the defense as to a plea, or, and I guess sometimes also open plea, so a plea. Now, at this stage, there are three ways for a case to be resolved. First, the state can dismiss the charges. Second, there can be a plea, whether that's an agreed upon plea or whether that is an open plea, and we can discuss those in a minute. And then the third way is a trial. Now, when it comes to dismissal by the state, that's rare. Sometimes the judge can order them to do it on a motion to dismiss if the judge grants that. Sometimes the state will dismiss after a motion to suppress has been granted and they lose the evidence they need to prosecute the case. Or sometimes they can be convinced, and these are rare, the state can be convinced that there actually isn't the reason to believe that a person has committed a crime. So they can change their mind after an indictment is issued. Now, with respect to a plea, let's talk about that for a second. A plea, typically we refer to it as a plea deal or a plea bargain or a plea agreement. Usually those are negotiated between the state and the defendant, where the defendant agrees to change his plea from not guilty to guilty, either to the entire indictment or to one part of the indictment or to what we sometimes call a lesser included offense. So a person may have been indicted for one crime, but they're pleading to something lesser. So once if that agreement is made, then what happens is there is an exchange there. That's why we call it a bargain. The person agrees to plead guilty in exchange for a recommendation as to sentence from the district attorney's office. Now, that recommendation is not binding on the court. The judge doesn't have to follow it. If the judge decides not to follow it, though, usually you can withdraw that guilty plea and or the petition to change your plea to guilty from not guilty, and then proceed forward on the trial track. But usually the judge will follow it. Sometimes the lawyer, we will go to the court ahead of time with the prosecution and make sure that the court is okay with the terms of the agreement before we go forward. Not in every case, but sometimes. Now, if there's no dismissal and if there is no plea, then we go forward to a trial. A trial will begin with what we call voir dire. The venire, which is the entire panel of prospective jurors, that whole pool will show up. They will be qualified by the judge to make sure they can sit. And then after that, voir dire takes place, and that's where the state and the defense will have an opportunity to ask questions of the venire and decide whether or not they like certain people. And everybody will be keeping notes, right? And then after that, there will be a break, and the parties will confer with the court, and they will go through different strikes. There's challenges for cause or strikes for cause, where one side may notice that a response from a prospective juror indicated that they might not be right to sit on this case. They may have said they couldn't be fair, or they have something in their past that is going to make them unduly biased towards one side. And then the judge will rule on that. The judge will decide, yes, that is a reason to strike this person for cause, or no, it is not. After the challenges for cause, we move into what we call peremptory strikes. And depending on the type of case, if this is what we call a capital case, capital little c, meaning that they're not going to be put to death, but that there is the possibility of life imprisonment as a sentence, each side will have 12 strikes. If this is not a capital case and something less than life is the maximum punishment, then each side will have 6 peremptory strikes. And these are strikes that can be used for really any race-neutral reason. You can't strike all the white people or all the black people or all the men or all the women. They have to be race-neutral reasons, like, this person is not a gun owner and this is an alleged gun crime, and we're afraid that this non-gun owner might hold it against the defendant that they owned a gun. So that's an example of a race-neutral reason that can be used for a peremptory strike. Or it could just be that This person was giving mean faces to the prosecutor or to the defense lawyer throughout the course of voir dire. Really, anything that's not a race-based reason or gender-based reason can suffice for peremptory challenges. And so each side, like I say, gets 6 or 12, depending on the case. And what happens is, functionally, the first available 12 jurors are tendered to the state, meaning they get to use their strikes first. And then after they've gone through those 12, and there are 12 left. So after they go through 12, let's say they use 3 strikes, 3 will then be added to the end. And if they accept those 12 are then tendered to the defense. And the defense gets to use their strikes the same way that the state used theirs. And it goes back and forth like this until 12 people are accepted. Then we move to alternate jurors, and it depends really on the judge as to how many alternate jurors they want and how many strikes will be given to each side for these alternate jurors. A typical number is 2 alternate jurors and then 2 strikes per side for these alternate jurors. So once the jury is selected, they will be seated and sworn by the judge. And then we have the opening statements from each parties. These are not opening arguments, rather, but opening statements where each side will tell the jury what they expect the evidence that they're going to hear will show. The state goes first, and then the defense can either go at that point or they can wait until the start of the defense's case in chief, which would be later. So after, and usually almost exclusively, we do ours before the state's case in chief. So the state would go and then the defense would go. That's 99% of the time how we do it, because we like to be able to get our spin on this to the jury before the state starts calling witnesses. So once the state and the defense have given their opening statements, the state will then start calling witnesses. They'll go through witnesses until they feel they have called all of the ones that they need to meet their burden, which at this stage, remember, is proof beyond a reasonable doubt. Before, everything was probable cause, but now that we are post-indictment, the standard is beyond a reasonable doubt. So when a witness is called to the stand, they are on what's called direct examination. The party that did not call them gets to have cross-examination. So in the state's case in chief, if they call a witness, they then get to ask non-leading questions of that witness, things like tell them what happened and what did you do next. And then the other side, in this case would be the defense at this stage, would get to cross-examine. And that's a totally different type of questioning. That is where you are essentially testifying on your own and asking them to agree with it. That's how cross-examination is done, and there's a whole other series of videos to be done on how to do cross-examination well. That's outside the scope of this particular video. After cross-examination, the state then gets redirect examination, where they get to stand up again and they get to ask questions, just like they did on direct, the non-leading kind, about things that were raised during cross-examination. Now, very rarely can a defense lawyer get what we call recross, but that's how the witnesses are handled during the state's case in chief. It's direct examination by the state, cross-examination by the defense, and then redirect examination by the state. At the end of the state's case in chief, they rest. And then the defense will make motion for a directed verdict. That is almost always denied because that motion has to be taken in the light most favorable to the state. That's some lawyerly talk. Don't really worry about that. Just know that that's what happens functionally next. And then the defense has the opportunity. They don't have to do this, but they have the opportunity to put on a case themselves. They can call witnesses themselves. They could call the defendant himself or herself. They do not have to, and the defendant, by law, by our Constitution, does not have to take the stand. And on top of that, the jury cannot hold it against them if they do not take the stand. That's the Fifth Amendment. So the jury would then be instructed later that they can't hold that against the defendant if the defendant chooses not to take the stand. After the defense's case in chief, the state can have what's called a rebuttal case. They can call rebuttal witnesses to try to prove that what the defense said was not true. After the state's rebuttal, if there is one, or the defense's case in chief, if there is one, the jury will then be given jury instructions. And what happens prior to that is the parties get together with the judge and they say, well, Judge, we think the jury ought to be told X, Y, and Z about the law. And then each side may agree or they may disagree. The court may agree or disagree. Ultimately, it is up to the court about what instructions should go to the jury that fit this particular case. And the instructions are basically statements of law to the jury. That's all that it really is to them, is this is how you are to decide the case. This is what matters in this case. So then what you do is the judge reads these jury instructions to the jury, and then you have closing argument. Just like throughout the trial, the state has gone first, the defense goes next, and then the state gets a rebuttal opportunity. They get that with closing arguments as well. Closing arguments range anywhere from sometimes as short as 10 to 15 minutes all the way up to an hour or more per side. So once closing arguments are complete, the jury then has the case. They will retire, that's the word that we use, to the jury room where they will deliberate about what they should do and whether or not they should find the person guilty. Now, there is a special instruction that lays out what the form of their verdict should be, how they should write it down. If the jury has questions, they will knock on the door and deliver that question in writing to the judge, who will then discuss that with the lawyer. Almost always, the question, if it doesn't involve food or going home for the evening, the question is responded to by the judge with, you have your evidence and you have your instructions. Please continue to deliberate. Sometimes a jury cannot reach a verdict. Sometimes you have people that believe one way strongly, and then you have people that believe the other way. And so in those instances, we call that a deadlocked jury. There's a special instruction that the court will read to a deadlocked jury. And if they cannot reach a conclusion after that instruction is given, then the judge will declare a mistrial. If there is a verdict that is reached, then the jury will knock and let the judge know we have a verdict. They'll come back out. That verdict will be announced in open court, guilty or not guilty. And then either side can poll the jury. They can ask the jury individually. They have the judge ask the jury individually, is this your verdict? Juror 1, is this your verdict? Juror 2, is this your verdict? Juror 3, all the way through. I have had instances, I've seen instances as well, where there was some disagreement still, where a juror said, no, that's not my verdict. And then a mistrial can happen then at that point as well. So that walks you through the entirety of the process post-indictment through verdict at trial. If there is a guilty verdict, and the next thing that will happen is sentencing. And it's sentencing, it's up to the judge. It's not up to the jury. The judge can have sentencing right after the verdict, or can set the sentencing off for another date. After sentencing, that is when post-trial motions are filed and the appeal process begins. So I hope that gives you an idea of the post-indictment phase of a felony prosecution and what happens and how it works. If you have questions, please don't hesitate to reach out to us. We do this all day, every day. It's what we're here for. Thanks.